Good morning. Welcome to our webinar. Today, Sue and I are going to be looking at directors' responsibilities in these uncertain times. Sue's our joint managing partner and also a specialist in advising general practice clients on a day-to-day basis about issues facing their businesses. Sue's also a licensed insolvency practitioner, as am I, so we've both seen issues for directors from normal day-to-day perspective, plus also the consequences for some directors when a business falls into an insolvency. If you have any questions, we'd be grateful if you could put them in the question and answer box at the bottom of your screen, and we'll answer them at the end. I think Sue's now going to kick off with just a little overview of some of the challenging things that are in the economy at the moment.
Thanks very much, Sandra. Hello, everybody. Well, I think it's no surprise, it's been well documented that the UK is in its most challenging economic outlook since the 1970s. Many issues coming from all sorts of different directions. So at home, of course, we've got the economic challenges. You know, we're sitting at the bottom of the table of G7 in relation to economic growth and potential recession. I think we're just skating along that recession line at the moment. High inflation, cost of living crisis, of course, surging energy prices, rising interest rates, supply issues. I mean, massive supply issues. I think we're seeing continuing on from the COVID-19 issues that we had, where there was the restraint around that. Just this morning, reading in the Times that supermarket shelves are going to become emptier, certainly for fruit and vegetables because of weather impact and so on as well. And I'm sure those of you who've been engaged in any sort of construction projects at home will know very well that it's getting very difficult to guarantee price of supply of components, let alone actually getting those components in. Got workforce shortages. Although unemployment is expected to rise in 2023, skilled workforce difficulties are endemic right through the UK at the moment.
We're certainly seeing that in our own practice, aren't we? So you struggle to get good people despite, great rounds for recruitment, etc.
Yeah, I mean, we've been fortunate in many ways, but yes, it is more difficult to recruit and to recruit the right people. So, we're lucky that we've got a good team, but it does impact because everybody is then fighting over scarcer resource out in the marketplace. And of course, we all see the wage demands, the strike disruption. News again this morning, junior doctors are planning to go on a 3-day strike next month. The significant governmental budget deficit and the corporate debt burden following on from COVID. Added into all of that, of course, we've got the post-Brexit red tape issues for exporters, prime ministerial changes, 3 prime ministers last year, and the mini budget, of course, and the impact of that. Before you start to overlay worldwide issues from political sense, war in Europe, still the rumbling on of COVID-19 with, again, new variants, the impact of China's reversal of zero COVID policy. Hopefully that's beginning to diminish, but of course, because again, we get a lot of supplies from China, then that impacts on the supply chain again.
There is still quite a lot of sickness, isn't there, being caused by that, and there's still a number of sort of days lost for both the UK and I would imagine China as well too, sickness from COVID.
That's right, very significant. And I think in the UK people have got sort of used to it now in terms of how you manage that in your workforce, but for many other areas and countries, certainly like China, where this is the first serious wave of COVID that they've really experienced, then that does become very significant. And then of course we have the impact of cybersecurity, misinformation, political interference and so on, and this is all putting a lot of pressure onto directors of any business whatsoever, and within the UK, because there are other factors that we all now have to start to think about. And as somebody running a business myself, very well aware that you might have a plan as to where you're going, but you have to really factor in all these other issues around you. And of course, then we have the impact of climate change as well, there's poverty, food insecurity. The point about food supplies being disrupted has been very much to do with poor weather, dry summer last year, followed by a lot of rain, then followed by a very cold period. I think I saw something that Lanzarote had 3 days of snow. And so, where you think that's where a lot of salad crops and so on are coming from, that sort of the Spanish area, then that does cause issues. And then we have economic as well as climate refugees and the issues within Turkey in terms of the earthquake. So a lot going on. So what's the impact for businesses? Well, you running your businesses will know all those sorts of issues very much are squeezing on profitability. Increased energy costs, the rising material costs are talked about, wage inflation. And many companies are trying to get round the wage inflation issue by doing a normal sort of inflation-linked wage increase, but then topping up for more, the lower paid within their organisations by a sort of a flat rate bonus. So that then doesn't get embedded within the whole wages and salaries spiralling up and spiralling up. There are challenges passing on increased costs because, of course, consumers and other businesses are thinking about how they might restrict their expenditure, and increased borrowing costs. So, bigger debt burden, rising interest rates. And for me, many businesses haven't necessarily factored in these sorts of issues in their longer term planning in the past.
And with the borrowing costs, I guess, so because some businesses will have borrowed quite heavily through the COVID period, that's a bigger issue now than it might have been pre-COVID.
Absolutely, unless they've managed to get a fixed rate, but most business lending will be based on base rate plus a percentage. So they're not immune to it, and it's normally fairly challenging to have fixed in the way that people have been able to fix mortgages. And then, of course, cash impacts, cash flow challenges, disruption to supply chains. And we've all seen post-COVID changes in staff working patterns, whether businesses like it or not. If you're unable to offer the more flexible or hybrid working environment to your staff, there's probably a competitor down the road who will offer that. And with staff shortages, then that becomes even more of an issue. Quite apart from, some businesses do have great challenges in making sure that a hybrid type workforce is actually working as effectively as they might do for their particular business. So where you need a lot of teamwork, for example, it can be difficult to foster that and challenging to adapt business practices and so on. And then, as we've all seen over many, many years, creeping red tape, having to do things in a particular way, and having to comply with more and more regulation. So there is an awful lot that is impacting on directors of businesses at the moment, which is why we thought it would be a good time to think about what those challenges might be and how, as a director, you might address them and what your responsibilities are. So I think the first thing to think about is, what is a director and why is somebody made a director? Very often, the term director might be used to promote somebody. There's no comprehensive definition of a director in statute, but in essence, it means a person who, together with other directors who form the board of directors, is responsible for the management of a company. The term director includes any person who occupies the position of director by whatever name they're called. So in some companies, management might be entrusted to governors or council members or trustees, but they will be treated as directors for company law purposes. Directors are, so calling somebody a director doesn't actually make them a director for company law purposes. It's a bit sort of back to front in a way.
So you could have a sales director that wasn't on the board? And
yes, absolutely.
Okay, but not really a director?
Yeah, because they wouldn't perhaps have that wider purview of management of the business. It is a term that is given to them perhaps as a promotion, you know, and their peer group might expect that once they get to a certain level, they're called a director.
Whereas potentially a trustee with no financial gain from a charity could be a director of that, or is a director of that entity, and takes on all the risks and responsibility but gets no reward. Is that?
Yeah, absolutely. That is absolutely the case. And you know, I think it's also interesting that a number of the banks appoint directors and area directors and so on of their business, and yet those individuals don't have any say in the running of that particular bank, so should not be held responsible for the running of the bank. So the question of what is a director really comes down to the actual reality of the role that one's playing. So if you're a person in accordance with whom the business is managed, then you are probably a director. And people talk about shadow directors, and this is particularly relevant. Sandra will come on to that when she's talking about insolvency and the impact of insolvency. But a shadow director is somebody in accordance with whom the company is inclined to follow their instructions, and they are a shadow director, even though they're not actually called a director on the board. So that could be somebody who's pulling the strings, as it were, from outside and telling a company director how to run the business. So that's something to just bear in mind.
And I sometimes see that, Sue, where you've got an insolvent entity and it's a husband and wife team, and one of them is a bankrupt, and the other one is stands in to look after that company during their period of bankruptcy, but the bankrupt is still really running the show.
No, I agree. And I mean, I think the other type of director that we see a lot of discussion around is the differing roles of executive and non-executive directors. So executive director is somebody who is in the business all the time, who's managing the business. A non-executive director is somebody who is expected by the board, and their role should be to be more objective, to cast that sort of objective view over the activities of the company and bring to board meetings a different perspective. Perhaps from their background, it might be a technical background, or it might be sort of, say, a finance background. It's very common to have non-executive finance directors who just talk, you know, influence the business that's carried by that objective view. But company law on directors applies similarly to all directors, and I think that is also something that is really important that people understand when they take on a governance role within any organisation, that the fact that they're not there all the time doesn't necessarily excuse them from bad behaviours that might be happening within the company itself.
Or the fact that they're not getting paid potentially as well.
No, exactly. And I think that's one thing I'm very alert to for people who are asked to become trustees of corporate charities, is that they then become responsible. And if the charity is not being run well, then the liability for poor performance could well fall upon the trustees who are non-executives as well. And yeah, that's not a good place to be, because somebody very often is joining a board of trustees as a non-exec or as a trustee to do good and to promote the interests of that charity. They're doing it in their spare time for no remuneration, and yet they could potentially jeopardise their day job as well.
It's quite scary, really, isn't it?
It is scary, and unfortunately not too many people are aware of that when they're taking that role on. And I think it's beginning to lead, rightly, to increasingly professionalised boards of trustees, I think, where people are taking things very much more seriously. But the problem with that sometimes can be, I think, that you see trustees then losing the perspective of the overall objective of that organisation, because they're more concerned with governance. So it's a very difficult balance. So I think we've.
In terms,
yeah. So I think we've probably more or less covered this, but effectively, what is a director? So strict statutory and common law responsibilities. A statutory director of the company is somebody who's very clearly a director. It's filed at Companies House. As we said, trustees of charities are also directors. And if you're not a statutory director, by being called director, you are a de facto director. So people outside in the outside world would expect you to have the responsibilities and influence of a director, and therefore, in many circumstances, can expect to treat with you, to expect to deal with you as if you were responsible for the management of their company. So that can be a difficulty in calling somebody a director if they don't actually have access to the management board of the company and the information that goes alongside that. And we've just talked about shadow director, somebody in accordance with whose instructions, like the spouse of somebody who's running a company, the company is accustomed to act but not formally appointed, so they would then be a shadow director. And then we've talked about the distinction between non-execs and executive directors. So then we come to, so why are there specific roles and what obligations and responsibilities for directors? Well, I think it comes back to basic company law. So if you have a limited company, the status of a limited company, or indeed a limited partnership, is such that in general, that means that the company has the privilege that any repayment of liabilities incurred by the company or partnership is actually restricted to the company. So in other words, a creditor of the company can't come after the director of that company for repayment of any liabilities if the company fails to pay that. Unlike, for example, a sole trader, where all liabilities go back to the individual. So the flip side of that is, in order to have that privilege as a director in running a company, then there have to be rules and obligations that are placed upon those directors and their conduct and the way, so they're required to conduct the business of the company and themselves responsibly. And this was more recently codified with the recent Companies Act. Have the next slide. So what are the obligations? Well, I said reference the most recent Companies Act 2006. So within that, also within other Companies Act requirements, and there are requirements under a whole range of other legislations that you find, and then there are also overlaid on top of that obligations within the articles for the company itself. So the articles being the governing Bible, if you like, of the company's internal structure.
I see from time to time, because there are so many other small bits of legislation where directors just were completely unaware of their obligations under those bits of legislation. I guess you may have come across that too as well, Sue, from time to time.
Yeah, absolutely. And that is some of those other parts of legislation are indeed where the corporate veil can be pierced, and that the corporate veil being the limited liability situation, and those are specifically in relation to negligence type things, so where a director can be deemed to have been negligent in his conduct of the company and the company's affairs.
And of course, there's now talk about making social media companies potentially their directors responsible for content online, which is a big hot potato, I would suggest.
Well, it's a massive issue, isn't it? Because there's one thing controlling the people who work within the business. There's a whole different ballgame trying to control the actions of people who interact with that company, particularly on the sort of scale that a lot of the social media companies are acting on. So next slide. So under the Companies Act, what are the duties? So directors' duties are to act within their powers, to promote the success of the company, to exercise independent judgment, exercise reasonable care, skill and diligence, avoid conflicts of interest. Now that's a really interesting one. So I work with a lot of technology-based businesses, And in many cases, because they're very reliant on external funding, many cases the investors will have a nominated director on the board, and they have to be really careful that they're thinking about the interests of the company at all times, not the interests of their principal employer, who is the fund and the investor. So that's the sort of scenario where you can have a massive conflict of interest. I think, another thing is, not to accept benefits from third parties. And that is very clearly designed to stop people from being swayed in their conduct of the company by other interests that would benefit them. And also to declare interest in proposed or existing transactions or arrangements for the company. So those last three are very much all bound up together. It's all supposed to be there to stop you from running the company with anything other than total focus on the company's affairs.
That can be really difficult and challenging where you've got directors that sit on a number of different boards.
Absolutely.
And with no interaction between those entities, they're not in group companies, but they're quite confusing for people.
Yeah. No, I agree. Absolutely agree. So next slide, please. And other companies, so there are other companies' act requirements apart from those specific duties and obligations. So ensuring that the company complies with its obligations to maintain adequate accounting records such that the status of the company at any one time can be ascertained. I think most companies now are quite good at that. It's very different from when I started in my career quite a long time ago now in accountancy, where people would keep very scrappy accounting records. And I think now the vast majority of companies are using an online or a digital sort of platform for their accounting. It's much easier for people to actually account appropriately and to meet this obligation. And then, what I'm sure all company directors are familiar with, that annually you have to prepare and file at Companies House financial statements by a due date, and ensure that the company also meets other filing obligations, such as the annual confirmation statement, details of changes in directors and changes in share capital. Now, that last one is really critical, and it's something that people often fall foul of, particularly in an arena where you're getting a lot of external investment. And it's very, very important that those documents are filed on time and correctly. We often see when we're reviewing accounts and so on at the end of the year, when we go into Companies House to check on filings, that the issue of shares has been misfiled for one reason or another. And this tends to be in the more complex areas. So I think it's something that most definitely you need your lawyer to really help you with if you just to get that right, if you've got complex share issues going on. Because it falls back, if it's not correct, it's something that falls back on the directors. It's their responsibility to ensure that's done correctly. Next slide. And then under other legislation, we said that there's a whole raft of. So for example, if a company is very large, so it has over 2,000 employees or turnover over 200 million or balance sheet total of more than 2 billion, then they need to comply with the Waits corporate government principles. There's another load of legislation and requirements that fall in. Then other things such as health and safety, environmental, data protection, anti-money laundering, every company needs to be aware of that. But for particular businesses such as those handling money or client monies, then that is becoming more and more critical. And anybody out there will know that when you go to open a bank account nowadays, it takes quite a while, just an interaction with a lawyer or indeed ourselves as accountants. You have to provide lots of forms of identification, and it's not as simple as it used to be, simply because we're all required to try and make sure that we spot the rogues who are out there trying to wash money through.
I think there's more of that coming down the track as well at us, isn't there?
Yeah, most definitely. And it's been interesting because we've certainly seen in recent times a number of banks, financial institutions not wanting to deal with particular sectors or types of client. and you know, many of which are very innocuous. So for example, trusts, you know, so family trusts and so on, a lot of banks are, because of the checks that you have to go through to make sure that people are legitimate beneficiaries and so on, and that you might have undisclosed beneficiaries, and they have, yeah, they're just not prepared to take that risk.
And all of that makes it much more difficult for the directors that are there trying to manage these businesses.
Absolutely, absolutely. So next slide. And so, you know, what are the consequences of a breach of director's duties? Well, you can actually have, as a director, you can have personal liability for a breach of general duties, misleading or false reporting. I think, you know, looping back to where we started from today about, you know, the challenging economic environment and so on, when you're under pressure as a director, be actually running the business, then sometimes you might, you know, you might be taking shortcuts, as it were, in terms of what you're you know, in terms of your accounting, in terms of you know, what you're reporting to Companies House and so on. You might not be up to date with your corporate administration. I referenced just now about the shareholding, share issues, and you know, things like keeping company registers, making appropriate filings. Again, that's something that could constitute a criminal offence, which people aren't always aware of. Certainly seeing companies, the directors suddenly get a letter from Companies House saying, we're taking you to court, by the way, this is criminal, because you haven't filed your accounts on time. And similarly, negligence in relation to the activities of the company may be a criminal offence, such as corporate manslaughter, vehicles being untaxed or uninsured. So, you know, if you've got company vehicles and you haven't kept up to date, made sure that the insurance is up to date, then you as a director are responsible, even if you have got somebody else within the organisation, a manager or something, perhaps running a fleet, who is supposedly responsible for that. Ultimately, it's your responsibility as a director. You
can't offload that responsibility onto somebody else within the organisation or outsource then to.
No, not at all. And that's something that, you know, where you're running a fleet, it can be an area that you can easily get into hot water under if you're not aware of the regulations and so on. And of course, you know, you can, if you breach your duty significantly, then you may be disqualified from being a director. And you know, the grounds for disqualification as a director are very extensive, including persistent breach of company law. But you know, and I come back again to this point about being a trustee of a charity. If things are going on within that charity that shouldn't be going on, even if you're not there on a day-to-day basis, even if you're not given all the information that would enable you to make a proper judgment or assessment of what's happening, you are still responsible for the conduct, because you are the person or one of the people that the general public have a right to expect is taking responsibility for the running and administration of the company.
So if you were such a trustee, Sue, and you didn't feel that you were getting the information that you should be getting, what should you be doing?
I think you've got two things you should be doing. Firstly, you should be requesting the information that you believe is there. And you know, you are entitled to receive whatever information you request. If you don't feel that you're getting a satisfactory answer, and you should do that if you're not confident you're getting a satisfactory answer, then you should be documented, you know, that should be documented. So it should be very formal. And if you still don't think you've got everything you require, then you should at a board meeting minute that. And I would also suggest that you should consider resigning from the board, because you're unable to exercise your role appropriately. And
if you do resign, presumably then you wouldn't be responsible for things that happen into the future, but you may still be held accountable for things that had happened in the past.
Yes, but I think that, you know, what we can see is that the courts do look at what is reasonable in the circumstances. And I think if you have noticed that you're not getting information within a reasonable time frame of something having gone wrong or whatever, then I think that that would be a deuce that, you know, that you couldn't do much more than you had done. If, however, when you get wind of something that may be a prosecution going on, you suddenly wake up and say, well, I don't want any part of this, and it's a very different thing. And I think, you know, you see that, don't you?
Yeah,
a little bit.
It's about being timely, isn't it?
Yeah, yeah. I mean, yeah, I know we've dealt with a number of insolvency jobs where suddenly you're coming toward companies in financial difficulties, and you've got directors trying to resign at the last minute to sort of wash their hands of it, which doesn't work, does it?
Not usually.
And I think that leads us on then, doesn't it, to you then having a bit of a view of what happens in insolvency.
Yeah, for sure, Sue. So there will be a period of time before a company enters into an insolvency procedure when it is nonetheless insolvent. So from that period on, the directors take on additional personal potential risks. So I think it's probably just worth explaining what tests that we look at to establish when a company fell into an insolvent situation. And obviously that is likely to be in some period prior to a formal insolvency taking place. So there are two tests, and if either of those two tests are met, then the company can be described as insolvent. So there's a cash flow test, and that looks at whether the company can pay its debts as and when they fall due. And that doesn't necessarily mean just because you've got a big liability to pay a COVID loan or something like that, that you're insolvent. As long as you're keeping up with the regular payments that you're expected to make under that, then you're paying those liabilities as they fall due. So you wouldn't fall foul of that test. But for example, if you've got, and many businesses are looking at this now, stretching the payment terms with creditors because they haven't got sufficient funds coming into their business to enable them to pay the creditors on 30 days or whatever their agreed payment terms are. Keep an eye open for that with the stretching of creditors, because that could be a sign that the cash flow test is being breached. Then the second test is a balance sheet test, and that's looking at whether the company's assets, the value of those assets, are less than the liabilities. And we also take into consideration in that test contingent liabilities and prospective liabilities. So maybe ones that aren't as apparent on the balance sheet, but you nonetheless need to take those on into consideration when looking at that test. But it's very important to point out that it's not illegal in this country for directors to continue to trade an insolvent entity. And indeed, many businesses do continue to, or directors continue to trade, and they turn things around. Directors just ought to be aware that there are potentially personal risks in doing so. And it's quite often looking at the ways of being able to mitigate those risks so that directors can get comfortable continuing to trade whilst a business is insolvent. Can I have the next slide, please? Thank you. So sometimes that period is referred to as the twilight zone. I know that was quite prevalent in the press a number of years ago. But once directors have identified that there is an issue or a potential issue in looking at the solvent position of, or insolvent position of the company, then their focus should change from that of creating wealth for the shareholders, which obviously is one of the primary objectives of a director, when you're not necessarily talking about charities here, but in normal sort of operating businesses. And they should be looking at protecting the interests of creditors, so that creditors are not exposed to or unnecessarily exposed to risks. And it's really important that the directors understand what personal risks they are facing in this twilight zone and take steps to mitigate them. And some of that, or a lot of that, will be around the information that they receive. So that'll be making sure that they receive the management accounts in a timely way to understand whether there's a cash flow issue or whether there's a balance sheet issue. And actually really interrogating those accounts and making sure that the things that are where there's some subjective element as to what's recorded in those accounts are the assumptions that people have made appropriate, and therefore are the accounts that they're receiving showing a true reflection of the company's state at that point in time. So that we would expect a board of directors to be meeting fairly regularly, looking at those, reviewing that performance and recording those decisions that they make as a result of the information that they have available. And so that having that good management information and having interrogating each other on the board. So you might have a sales director that's very optimistic on the board, and perhaps it should be the function of other directors on that board to say, well, how realistic are these forecasts that you're saying that you've got there in terms of sales? But equally, you might have someone who's very pessimistic on the board. And again, it's the role of the other directors to make sure that what they're saying, it shows a balanced view as to what the true position is. Next slide, please. So we sort of move on to mitigating the risk. So directors have decided that the financial state of the company is such that it is either insolvent or potentially soon to be facing insolvency. Then what should directors be doing? Should they be continuing to trade, or should they not be continuing to trade? And that's probably the biggest question that they ask. So in terms of if they have continued to trade, is there a turnaround plan? What is going to make this business profitable again and potentially repair a balance sheet or improve a cash flow position? And does that turnaround plan enable that to happen in a feasible timescale? So and feasible might be different for different types of businesses. And so therefore it's quite important to look at it in context. You could have a plan that's feasible, say, for a large property related business that took place over a number of years in terms of mitigating that risk, whereas potentially a retail unit might only have a number of months to effect a turnaround plan. So it's looking at it in context and looking at it regularly to make sure that that turnaround plan is on track and should trading continue. So you should be looking at that decision fairly frequently, probably monthly, possibly in more critical phases more frequently than monthly. So some boards of directors, when you're in a very critical phase, might be meeting on a weekly basis to review the decision as to whether trading on is appropriate. Directors will also be looking at where potentially they've got a cash flow issue, is additional finance available? And you know, there are obviously the traditional, you might go and ask your existing bankers first, but as the position worsens, the pool of people that will provide additional finance tends to get smaller. Certainly where Sue was talking about with technology businesses, going back to the existing investors and explaining to them that there is a funding requirement and seeing whether additional funding is available.
And I think that's something, isn't it, Sandra, that, you know, if the business is in some form of distress, which we're talking about now, that a bank would typically expect, or a traditional funder would typically expect the shareholders, investors and stakeholders to take some of the pain themselves. Absolutely. You know, and I think certainly that was a feature of some of the CBILS loans as well, were you know, many were facing restrictions in terms of if they receive loans around that period, that they shouldn't be drawing dividends or anything like that, because the funding wasn't there to enable that. And I suspect that that's something that carries on now in terms of the traditional funding.
I certainly agree with that. Talking about the deterioration there, and I think taking action quickly, we were just sort of speaking about directors and what should they do if they weren't getting enough information, but I think that equally applies to, there's a deterioration, directors are spotting that there's a deterioration, and if they act quickly and appropriately to halt that deterioration, or to decide that it's time to put the company into a formal insolvency procedure, then the risks that they run are personal liability are much smaller than if they allow things to drift and thinking that things will get better. So the ostrich effect definitely works against directors in such situations. But really, they should be thinking very hard about taking additional credit in that period. So it's quite a difficult one, because if you want to keep a business afloat and you want to keep it running, then you will need supplies. But should you be incurring additional credit? Should you be putting other companies at risk because you want to take credit from them? I think as long as you've got a turnaround plan that is comprehensive, well thought out, and is based on reasonable assumptions, then the risk of taking further credit is probably reduced. But if you just take additional credit from another company and put another company at risk without having anything that's approaching a well thought out plan, then you potentially will be incurring personal liability if the business then fails. And I will come on to that in a moment. But you also need to have a think about which creditors you're going to be paying if cash is tight, and certainly, and I will come on to this in a moment, paying connected creditors. So maybe another business that has common ownership that has lent the company some money, for example, that could get directors into hot water. And also, if you're taking customer deposits, what should you be doing with those? So somebody's, I don't know, you're running a hotel and you've got a wedding coming up, and there's a deposit that the bride and groom have been asked to put down. Should that money be going into the general pot, or should that money be put in a trust account? And I think if you're being cautious as directors, then the best option there would be to put that money into a trust account, so that if things did go wrong, those customers could get that money back.
Because ultimately, it's those customers' money, isn't it? It's not actually your money at that stage.
Until you've delivered that service, you're right, yeah.
And we've certainly seen sort of, say, kitchen or bathroom fitting companies taking hefty deposits in order to go and purchase materials, perhaps for the previous job that they're working on, to just keep and that's all very well as long as your revenue's going up. But when you get to a stage where it's coming down, then that starts to become more challenging and indeed inappropriate.
Indeed. Can I have the next slide, please? Thank you. So if the turnaround plan doesn't work, you're likely for a business to go into an insolvency procedure, and that could be administration, it could be liquidation, it could be a voluntary arrangement. And at this point, you will be dealing probably with an administrator or a liquidator, or potentially a supervisor of a voluntary arrangement. The administrator and liquidator have certain obligations in terms of looking at directors' conduct, whereas a supervisor in a voluntary arrangement doesn't. So all that I say in the rest of the slide relates to only a company that's gone into administration or liquidation. So the insolvency practitioner needs to investigate the conduct of the directors that have held office in the 3 years prior to the date of the insolvency. Purpose for that being twofold. One is to report to the Insolvency Service, and the Insolvency Service use the information within that report to identify whether there is any action that should be taken to disqualify directors. And the second purpose of that investigation is for the liquidator or the administrator to see whether they should be taking any action to recover monies from directors or others to benefit the creditors of the insolvent estate. So the Insolvency Service do the disqualification of directors, and the insolvency practitioner looks to recover monies for the benefit of creditors. And we also have an obligation, as you might well expect, to report any criminal activities to the relevant authorities. And that might range from breaches of data protection through to anti-money laundering breaches. And going back to the cars that aren't insured, there is an obligation to insure cars, and potentially criminal liability flows if you don't. So as insolvency practitioners, we do end up having to police some things that have gone on previously, sadly. Next slide, please. So the Insolvency Service, as I said, they're responsible for looking at whether a director should be allowed to continue to operate as a director. So they do an investigation into directors' conduct, having received our report, and they would receive our report within the first 3 months of the insolvency happening. And where appropriate, they can seek either a disqualification agreement that avoids them having to go to court, or a disqualification order, which is typically where a director doesn't agree to being disqualified for a period and seeks to defend an action by the Insolvency Service. There are 3 bands of disqualification, and so for the least serious offences, a director may be disqualified for between 2 and 5 years. More serious, 6 to 10 years, and the most serious, 10 to 15. And as you might imagine, there are fewer that receive 10 to 15 years disqualification, and more that receive the 2 to 5 years disqualification, but nonetheless pretty disruptive for anyone that receives a disqualification order.
Because it's not just, it doesn't just affect your ability to be a director, does it, of course?
No, that's right. So it may well have an impact on other things, such as being a school governor, or it might have impact on your ability to be able to borrow money, to earn a living. It is quite wide-ranging, potentially, the impact of being disqualified. Next slide, please. So what are the Insolvency Service focusing on these days? So they will look at that point in time when insolvency first starts to bite. So when the directors allowed the company to continue to trade when it couldn't repay its debts. And those directors knew, or ought to have known, that. So the test is whether a reasonable director, given the information that the directors had at that point in time, would have allowed that company to continue to trade or not. And if they should have stopped earlier, what is the impact for creditors? So did you continue to take on credit during that period? So at the point in time when you should have stopped, say creditors were owed £500,000, but by the time, say 6 months later, when you did actually stop, they're now owed, say, £1 million, then those directors could potentially have made it worse for the creditors of the company to the tune of £500,000. And that's obviously very serious. They're also very keen to make sure that the directors had the right accounting information at the time when they were making these decisions. And it's not an excuse not to have the right accounting information on which to be able to make a decision as to whether it's appropriate to continue to a trade or not. So one of the areas where directors are disqualified is for keeping inappropriate accounting records. And Sue was speaking a little bit earlier about lots of the online packages and people actually being able to record their own accounting information. So there's less of an excuse now that I didn't have the ability to be able to record the financial position of the company. But there is always the old adage, rubbish in, rubbish out. And I do see that from time to time. You know, people not really thinking about what they're putting on into their online accounting systems, and therefore making decisions based on inaccurate accounting records.
Yeah, and I think actually, I mean, that's interesting. You say that one of the biggest areas, I think, of inaccuracy is around stock and so if you've got materials and work in progress, it's really important that you keep a proper track of that, because that's the thing that influences whether you're profitable or not profitable. And you could easily find yourself, particularly again as we come on to all the pressures that directors are under at the moment, you can easily find yourself just not keeping track of what's going in and out of the warehouse.
And there can also be some sort of subjectivity to that. So when you're looking at old and obsolete stock, you don't want to take an optimistic view on that, do you? You want to take a realistic view on what you can actually sell that sits in your warehouse.
Yeah, most definitely, because then you come back to your point again, at what point should you as a director know or ought to have known that there were problems within the company?
Absolutely. So Sue touched on not sending accounts and returns to Companies House. Well, the Insolvency Service don't like that, because that is the only record that quite often other companies that are trading with your company will be able to see. So if you're not sending your accounts to Companies House on time, how can those entities make any judgment about your creditworthiness, etc.? I suppose you've got to then question, if people aren't actually filing accounts on time, why would you actually extend credit to them? But it is nonetheless an offence not to file those accounts.
And I think that's an interesting point again, because I think there's been a fair raft of companies that took advantage of the COVID regulations, the changes that the government allowed, which meant that you could extend your period of filing, to file your accounts at Companies House by at least 3 months. And I think a number of companies don't yet seem to have got themselves back into the routine of having to file within 9 months of the financial year end, and are seeking to then extend again. And we find that Companies House are getting much more resistant to that again now, which is appropriate.
We hopefully moved on to a large extent from where we were 3 years ago. And the Insolvency Service, not unsurprisingly, get pretty upset when when companies haven't paid tax. They refuse. They look at HMRC as an involuntary creditor, and if other suppliers to the business are being paid and HMRC aren't being paid, they consider that to be inappropriate. Now, I would caveat that with saying that if you have a time to pay in place with HMRC, then that is mitigation of that issue. But you obviously need to make sure that you are continuing to keep up with the payments as required by that time to pay arrangement. And then using company money or assets for personal benefit, that obviously is considered to be inappropriate, which probably brings me a little bit on to the government COVID loan support, where there's been press reports of people receiving bounce back loans, taking the money out of the company and buying themselves a very nice car with that. Those things are going to be under the microscope going forward. And certainly there is a whole new raft of questions that the Insolvency Service asks the insolvency practitioner when filling in their report to them about the support that they've received from the government in relation to COVID, and whether that support was appropriately obtained in the first place, and then whether the support was appropriately used. So there is a big focus on that as well. Next slide, please. So what does disqualification mean? Well, as we looked at on the previous slide, it is for a defined period between 2 and 15 years. And in that time, directors cannot be a director of any other company registered in the UK or an overseas company that has a connection with the UK. And I would say that there are circumstances where potentially that you might be able to apply to court to enable you to continue to be a director of a company that you were already a director of at the point of disqualification, but the courts don't look terribly favourably on it. So it is, you know, a big concern for directors. And you can't be involved in forming, marketing or running a company in the UK. And we were speaking a moment ago about the husband and wife team where one of them is made bankrupt. Well, this is a similar situation. What they're trying to avoid here is one of a husband and wife team, for example, being disqualified and the other one then becoming the statutory director. But the director that's been disqualified continues to run it in the background. And breaking the terms of the disqualification is a criminal offence and could lead to a prison or a custodial sentence or a fine. So it's pretty onerous in terms of being disqualified. So next slide, please. Other implications of being disqualified. We did go through these. You can't sit on the board of a charity or a school or a police. You can't be a pension trustee. You can't be registered as a social landlord or sit on the board of health or social care body. You can't act as a solicitor, barrister or accountant. So it is wide ranging potentially. Next slide, please. And then looking at what the insolvency practitioner might do as opposed to the Insolvency Service in terms of disqualification. Again, as I need to point out, this relates to liquidators and administrators, but not the supervisors of a voluntary arrangement. So liquidators and administrators might consider bringing claims against directors, which would result in that corporate veil being pierced and actually requiring directors to pay personal monies back into the company. And the common grounds that we look at there are for misfeasance and breach of duty, which we've spoken a lot about, falsification of company records and false accounting, wrongful trading, so continuing to trade for at the point in time when you should have stopped, and things got worse for creditors, fraudulent trading, so setting up a business for a fraudulent purpose or undertaking a fraudulent trade, transactions at an undervalue, so gifting stuff away to other companies or yourself, or receiving goods at a value that was significantly worth where they were significantly worth more. A typical one there might be a builder puts an extension on the back of their own property and doesn't pay an appropriate value for that, so the company therefore loses out. And then preference, and that's putting one creditor ahead of another, especially where that party is a connected creditor. So it might be paying off a loan that a director put into the company prior to the date of the liquidation or administration, and other creditors losing out as a result. Moving on to the next slide. So what do we just think about before we take such actions as insolvency practitioners? Well, we need to make sure that we've got good grounds for bringing any such claims. We look at how likely you are to succeed, and how likely, if we were to succeed, we'd actually recover anything. And then, of course, going to court if we needed to, the costs of that are not inconsiderable. So how would we fund it? And also, how would the creditors of the companies view any action that we might take? And we also look at, as a first port of call, rather than going to court, whether settlement can be reached with the directors, maybe through mediation. So those are the type of things that we look at as insolvency practitioners. So in summary, our final slide, please. You need to check whether you could be considered a director of the company, and that doesn't mean to say that your name is at Companies House as a director. As Sue was pointing out, you could be a shadow director, you could be a de facto director, or you could be a trustee of a charity and not really realise that you were a director, for example. And you need to understand what obligations and duties you have as a director, and think particularly about what's pertinent to your industry. So health and safety legislation might be much higher on somebody's priority list, for example, where you run a construction company, as opposed to somebody that has a small office. And just so looking at it in context, what does your company do, and what obligations do you have as a result of what the activities that your company undertakes? Be very aware of the financial position and what is going on in your company. Take an active part, even if you're a non-executive director. Ask inquiring questions. Take an interest in your fellow directors' actions. What are they doing? Make sure that you know who you're on the board with. Understand the finances. If you don't understand, ask. There's no shame in not understanding quite what you're being presented to you. Ask inquiring questions. And if you think that there's a problem, take advice early and act promptly and appropriately, because you'll have a lot more options there. And if you are going through a turnaround, monitor the performance against the plan, make sure you're on track, and discuss and document any key decisions that you make as a board, because that will be good evidence as to what you knew at the time, rather than with the insolvency practitioner looking backwards with 2020 vision.
I think that's also very good practice generally, even if the company is not in any difficulties, is just to make sure that you do have regular board meetings and you document those, and also that make reference to the material on which you're basing assessments and judgments, because you never know who might actually want to look at your board minutes and look at, you know, your considerations in terms of running the business at a future point.
Yeah, and they will then be able to know what you knew at the time, rather than exactly. Look back and think you should have known this, this, and this.
Yeah. Absolutely. So, questions now. Now, I'm very aware that we're just up on time, but we have time, I think, for one question. Sandra, one that I think is quite pertinent in terms of what you've been talking about is somebody has asked that during the COVID period, there was a bit of an amnesty, wasn't there, in terms of actions that could be taken against directors, with the idea of that people might inadvertently slip into doing things appropriately. And the question is, do you see that leniency is continuing, and do you think that the government might bring something back to say hands off, given that we're trading in uncertain times?
Okay, so that provision was specifically in relation to wrongful trading, and was revoked quite some time ago now. I don't see that there aren't a huge number of wrongful trading claims brought each year in any event, but I don't see the commercial reality that the government would bring that back in these times. Yes, they are difficult waters to charter, but they are not unprecedented like the COVID situation where the whole world didn't know where we were going. I think directors can probably have a bit more foresight about their business now. Yes, it's difficult to manage, but I don't think it's exceptional. I don't know if you have a different view.
No, I mean, I would very much take the same view as yourself. I think that if one is in a position at the moment where things don't go well, and as a director you end up in a situation where somebody, an insolvency practitioner, is taking action against you, I think it's unlikely that anybody will say that's okay because the situation was so difficult because of the economic forces, unless things started to come totally out of left field. And I could think of potentially a few construction companies that might suddenly not be committed, be partway through a project, and then supplies just don't turn up. And if they're on one of those time related contracts, i.e. you've got to get it done by X period, and they've got to have all their resources dedicated, so they've got no other work, then you could see that there might be some more leniency involved in those sorts of scenarios. But I think that's very much for a court to decide rather than actually a governmental decision.
Agreed.
But anyway, so I think that brings us just after 11 now, but to the end of our webinar for today. Hope you found it useful and interesting. And if you do have further questions or just want to have a chat with us about anything, but particularly circumstance relation to what we've been talking about, then you've got our contact details up on the screen now. And if you don't quite get those taken down, then we are on our website as well. But thank you very much for your time, and thank you for listening, and look forward to speaking to all of you in good circumstances rather than more challenging circumstances. Take care. Bye-bye.
Bye-bye.